SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. The Child Justice Act recognizes that before 1994, South Africa had not given many of its children the opportunity to live and act like children, and also that some children, as a result of circumstances in which they find themselves, have come into conflict with the law. The Act provides for specialized child justice courts, set up to deal with cases involving children who are in conflict with the law. In certain cases, the court may decide that a child offender is an appropriate candidate for diversion, which means that the child should be kept away from the mainstream criminal justice system and dealt with in an alternative fashion.
The primary objectives of the Act is, firstly, to establish an appropriate regime for dealing with child criminals. It is also to provide for a mechanism for the investigation and assessment of the capacity of specific children, or children who are involved in any criminal activity, to be tried, their capacity to understand their conduct, and the circumstances under which they found themselves in committing the crime.
The reason why we have diversion as an option in the criminal justice system at this point of time is that in the older days, children enter into the criminal justice system and they were exposed to hardened criminals. They were locked up for long periods of time. And in the end of the day, there was no transformation.
There are two levels of diversion. Level 1 option diversion is for Schedule 1 offences. That is for the less serious offences. Diversion is not a soft option. A diversion order for a Schedule 1 offence for children between the age of 10 to 14 can last up until 12 months. And for children between the age of 14 and 17, it can last up till 24 months. For the more serious offences, the Schedule 2 offences, is that the child be placed for intensive therapy. For instance, if the child have a drug problem, he can be sent for intensive therapy, and also to be placed under a probation officer, that will be the social worker, for a period of time, and also for him to have a compulsive residence at a school or an institution that is suitable for that specific child's needs.
Not all children are suitable candidates for diversion. So your serious type of crimes like murder and rape, most of the times will not go into diversion programs.
Children in conflict with the law have legal rights from the start when they get arrested. They have a right to be assessed by a probation officer within 24 hours. They have also the right to appear at the Child Justice Court within 48 hours.
Any child that was arrested have to be reported to a probation officer. So from that point of time, even before the child enter the holding facility area or the court, the probation officer are starting with collecting information. This collecting of information will also then continue during the assessment phase, where we look at different aspects like family background, previous history of uncontrollable behavior, previous interventions that was rendered to the child in order to address certain behavior.
The Act distinguishes between the types of offences and how each shall be dealt with. It is also important that the children should be dealt with differently. Even though the crime is the same, let's say theft, it should be dealt differently when committed by a child and when committed by an adult. And that does not necessarily mean that all it means is that the child must appear in a court different from an adult. It means that the investigation, the running of the trial, the sentencing of the child, consideration of the circumstances of the child should all be taken into consideration. Now, all that establishes a specific system for children, and that is the purpose of the Act.
After years of dealing with her rebellious stepson, Marguerite finally decided to lay charges against Donnie, resulting in him being tried by the Child Justice Court.
So toe gryp jy die pepersproei en beweeg na die voordeur toe.
Dis reg. Ek het hom gesien en toe hardloop hy by die voordeur uit. En dis toe dat ek die polisie bel.
Hoe oud is die dogters?
Natasha is 5 en Jessica is 8.
Was hulle bewus van wat gebeur het?
Ek het probeer dat hulle nie my gesprek met die polisie hoor nie, maar Jessica het dit gehoor en sy het geskrik en toe het Natasha begin huil.
Wat presies is gesteel?
'n DVD-speler, 'n CD-speler, 'n MP3-speler en 'n iPod.
En die totale waarde van die items?
Ongeveer R15,000.
Geen verdere vrae nie, edele.
Mevrou de Wet, meld asseblief u verhouding met die beskuldigde.
Is my man se seun.
U stiefseun.
As dit toe jy dit wil stel. Ja.
The problem is the stepmother to the youth offender has been to the police station many times to complain about the behavior of the child. And I would like to believe that the police official involved just assumed that this is not the first time offender because the mother has been at the police station on numerous occasions. Unfortunately, the formal docket was not open until this incident.
This was the stepmother. The child actually disrespected her. She actually went to several trouble to actually report the case to the police in order to get help. The police didn't refer her for our early intervention programs because we have programs for children who didn't commit crime yet in order to address their behavior. And I think at that point of time she was totally desperate. And there was a total breakdown in the relationship between the two of them.
I think she didn't know what to do with the child and she was actually seeking for help. And that is where we came in and we assisted her.
Coming up, what drove Marguerite to press such serious charges against her stepson?
Dus terwyl u man weg was van die huis, het u 'n kriminele klag gelê teen sy enigste seun.
Ek het 'n klag gelê teen 'n misdadiger.
The Child Justice Act 75 of 2008, in line with the Constitution, emphasizes the best interests of children and provides the possibility of diverting matters away from the formal criminal justice system. When a child first comes into conflict with the law, a preliminary inquiry must be held to establish whether the matter can be diverted. If not, the inquiring magistrate may refer the matter to a child justice court.
The consequences of a young person being exposed to the criminal justice system now, we have to talk about prior to the implementation of the Child Justice Act, was that children were exposed to criminal factors, they were locked up, and there were no programs to actually address their needs. With the new system, we say we want our young people to understand that the whole diversion process is actually a learning opportunity for them, for their family, but also for the community where they live in. Very important in the diversion process, we want our children to take responsibility.
The Act seeks to bring into effect the rights of children that are enshrined in the Constitution. But at the same time, the Act recognizes that a child has caused an offense to society at large. And when a criminal case is held, the judge must at all times weigh the two sets of rights, that is the rights of the child and the rights of the society. A society has a right not to be harmed. It has a right to protect itself or to seek protection against harmful conduct by anybody, including children.
So u is Donnie se stiefma.
Ongelukkig ja.
Waar is Donnie se biologiese ma?
Is oorlede aan kanker. 'n jaar voordat ek en Jaco getroud is.
Dus deel Donnie die huis met u dogters en u man?
Ja,
En waar was u man tydens die voorval?
in Johannesburg. Hy kom net naweke huis toe.
Het u iemand gekontak voor jy saak teen Donnie gemaak het?
Nee,
Dus terwyl u man weg was van die huis, het u 'n kriminele klag gelê teen sy enigste seun.
ek het 'n klag gelê teen 'n misdadiger.
Volgens die proefbeampte se verslag is Donnie die kaptein van sy skool se rugbyspan.
So?
Was u bewus daarvan dat Donnie R500 nodig gehad het vir 'n skool rugbytoer?
Ja, ek was bewus.
Ek stel dit aan u dat Donnie geld nodig gehad het vir 'n rugbytoer.
En ek stel dit aan u dat ek vir Donnie gesê het hy moet vir sy pa vir die geld vra.
En is dit nie u verantwoordelikheid om vir Donnie te sorg terwyl sy pa weg is van die huis af nie?
Te sorg ja, maar nie toe te gee nie.
Weet u wat Donnie met die items gemaak het wat hy uit die huis geneem het?
Hy het dit verkoop.
En weet jy wat hy met die geld gemaak het?
Nee, ek weet nie.
Het jy oorweeg dat hy dalk die geld gebruik het om vir sy rugbytoer te betaal?
Dis nie die punt nie. Hy het by ons ingebreek en goedere ter waarde van R15,000 by ons gesteel.
Dis nie noodwendig die waarheid nie, is dit? Mevrou de Wet, hier is 'n brosjure van City Electrics.
Ek kan dit sien.
In die regterhoek 'n DVD-speler vir R499. 'n hoë troustel wat bestaan uit 'n radio met 2 luidsprekers, 'n MP3-speler en 'n CD-speler ter waarde van R1350.
En jou punt?
Ek is bloot nuuskierig oor hoe u by die bedrag van R15,000 uitgekom het, wanneer dieselfde items nie die helfte van die prys kos nie. So, u wil dus hê die hof moet u eie stiefseun aankla vir gesteelde items ter waarde van R15,000, terwyl die items in werklikheid nie 'n fraksie van die geëiste bedrag werd is nie. Ek probeer bloot verstaan hoekom u so oordryf. Hy's per slot van sake u stiefseun.
There was a big discrepancy. She exaggerated the amount of the value of the goods that were stolen from her house.
The stepmother actually opened a case of housebreaking affair for R15,000. In the end of the day, that was not the value. And this is part of our work here, is actually to get to the real value. Because the value involved will place the child in a different schedule of offense, which in the end of the day have an impact on your diversion options that you're going to use. Or even the fact that we can say, but you know what, the value is too high, we have to prosecute.
The law stipulates that a theft is committed when one takes an object or anything that they know is not rightfully theirs with an intention to appropriate for themselves permanently. Now, that will always be theft. So in the case under reference, it's not really a question of what the child needed it for that will determine whether or not it was theft. It must first be theft. And then the court will consider the reasoning of the child, the mental capacity of the child, and the mind that the child brought to bear on the conduct, and the circumstances and situation that led him to do that.
Coming up, will Donnie be able to convince the court that his case should be diverted?
Ek kom nie met my stiefma oor die weg nie. Ek dink nie sy hou baie van my nie.
Donnie, gee asseblief vir ons jou weergawe van die gebeure.
Ek is jammer.
Donnie, jy gaan 'n bietjie harder moet praat.
O, jammer.
Als reg, gaan aan.
Ek is baie jammer oor wat gebeur het. Ek het teruggekom van skool af. My stiefma en my 2 susters was nie by die huis nie. So ek het die radio, MP3-speler en DVD-speler gevat en aan my vriend verkoop vir R700.
Hoekom het jy dit gedoen, Donnie?
Ek het R500 nodig vir my rugbytoer. Ek het my stiefma gevra om te help, maar sy het gesê ek verdien dit nie.
Hoekom sou sy dit sê?
Ek kom nie met my stiefma oor die weg nie. Ek dink nie sy hou baie van my nie. My 2 stiefsusters kry alles wat hulle wil hê. Sy behandel hulle baie beter as wat sy my behandel. Ek word nie toegelaat om vriende huis toe te bring nie. Sy koop nooit nuwe klere vir my nie, of gee sy geld nie, tensy ek die tuin of motorhuis skoongemaak het nie. Ek sou dit nie gedoen het, as sy maar net my belange ook graag gesien het nie. Ek het nie bedoel om dit te doen nie. Dis net, ek het nie geweet wat anders om te doen nie. En juffrou Marie?
Ja, Donnie?
Ek het nie by die huis ingebreek nie. Ek het 'n sleutel.
Edele, volgens die proefbeampte se verslag is Donnie se pa bereid om familiegroepsterapie te probeer. Dit is duidelik dat Donnie geen tekens van kriminele gedrag toon nie en dat die saak aangespreek kan word deur die maatskaplike dienste. Die Departement van Maatskaplike Ontwikkeling sal die diens lewer wat waargeneem sal word deur die proefbeampte van hierdie hof.
Edelagbare, die staat beveel aan dat hierdie saak afgelei moet word. Nie alleen sal Donnie voordeel trek uit die programme wat aangebied word nie, maar die ouers sal ook.
The problem with the stepchildren, the fact that you are not being raised by your own biological or father or mother, for that on its own is a problem. And the treatment they get sometimes is not good. So different children react differently to different problems. So I think this one was his own way of showing that I have a problem. He was trying to express himself that we are not getting along. He wanted attention.
If there's no belonging in a family, if the child don't feel belong due to certain things that you can pick up, and in the assessment you will then pick up why the child don't feel belonging in the house, you will then get a child that will feel belonging with peers, and then you will get children that will really go out and sometimes commit crime. We try in the assessment phase to actually look at the child behind the crime and not the crime as per se.
Either the prosecutor can give a child a second chance to undergo other programs, but obviously it is going to be on strict conditions. Or the prosecutor can decide that we are proceeding with prosecution because you had your chance, you didn't want to use it, you don't want to listen, then you are proceeding with prosecution. And obviously, if the child is convicted, the court, the presiding officer is going to give the sentence that is going to redirect the behavior of the child. So those are the two options that are available to the prosecutor in charge.
1 week later, after some serious soul-searching, the De Wet family returned to court to hear the court's verdict about whether the case should be diverted.
Eerlik is duidelik dat die gesin baat sal vind by die diens en ingryping van 'n maatskaplike werker. Die feite in die dossier is verkeerd aangeteken. Duidelik is dit nie 'n huisinbraak met goedere gesteel ter waarde van R15.000 nie.
Dis 'n bevel van die hof dat die saak sal gaan vir afleiding. Volgens artikel 49 van die Kinderwet sal die jeugdige verplig wees om sekere programme by te woon, veral die gefokus op lewensvaardighede en verantwoordelike lewenswyses. Bykomende gesinsterapie sal deur al die lede van die gesin bygewoon word.
I don't really think that the mother wanted the child to be prosecuted. It was just a desperate cry. It was a plea of a woman who was hopeless. She didn't know what else to do because she has been reporting the child as a problem child to the police, and she couldn't get the help that she was expecting until she feels that maybe if the child is prosecuted, then he will get to learn something. Definitely she agreed to the family conference because she could feel that it is going to be in the best interest of her family together as well as the child's best interest.
The court has at all times uppermost in its minds the interest of the child. In sentencing the child, the aim is not to destroy the child. The court's or the justice system primary objective is to correct the child's error, to ensure that the child gets back on a correct path such that they can develop into a useful member of society. So in the case such as we had, this was a most unlikely candidate for crime, this child, and that must be taken into consideration. The pressure that he found himself under at the time will also be taken into consideration. His age and his ability to resist external pressure and do what is right is again another issue for consideration. So when it comes to sentencing, It is not only necessary that you send the child away for 6 months to prison, because what comes back might be starkly different from what went in.
As far as possible, we try to rehabilitate the children back into the community and try to keep them out of prison. That is why the Child Justice Act makes provision for sentencing of children, and also part of that is the diversion option that we give them to allow them to rehabilitate out of the criminal justice system in the community, to give back to the community what they have taken.
Wie al julle, dit was 'n lang, soms moeilike proses, maar julle het dit gedoen. En ek hoop werklik nie om weer julle lelike gesigte gou weer te sien nie. Jy is natuurlik die uitsondering. Dankie. O, amper het ek vergeet. Hoe het laas ek met jou rugbywedstryd gegaan, Donnie?
Ons het verloor, maar dit is oké. Ons was vrot.
Julle was nie. Die ander span het skelm gespeel.
Nee. Julle was vrot.
Pa, jy stink.
Dis nou wat ek graag wil sien. Julle beklei soos 'n doodgewone familie.
What is at issue is how to deal with children who find themselves in conflict with the law. It would not be appropriate to deal with them in the normal criminal justice system, because that was designed and is executed for adults. And part of the issue with children is whether or not they had the necessary criminal capacity to do what they did. There has to be a system designated specifically for that purpose, and a system that runs along the lines of protecting the child and looking into the best interest of the child.
When you deal with children on a daily basis, you get to empower the youth of today, and you learn also to understand other cultures on a daily basis. And you also learn as a legal representative to see the social and the economical hardship of the children, where do they come from. And I can just say it's very satisfying to see the success stories of children that you really can assist.
You want him to understand, or her to understand, that, you know what, we are here for you. Yes, you have done something wrong and you have to pay the consequences. You have to go through programs. But we are here for you. We believe in you. We care for you. And we are here to actually guide you to develop yourself in a law-abiding citizen.
When a child comes into conflict with the law, a preliminary hearing is held to decide whether the child is a suitable candidate for diversion. At the preliminary inquiry, the magistrate considers the probation officer's report and finds out whether the youthful offender has committed any previous offenses. Diversion is an attempt to channel out youthful offenders from the mainstream criminal justice system, and may involve counseling, life skills programs, and family group conferences. Diversion is only chosen as a suitable option for less serious offenses. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.